provide his professional services. From the pleadings of the claimant, he was engaged by the defendant as the first defendant project coordinator under a freelance contract agreement to provide his professional services. But after the commencement of the contract, the claimant noticed shortages in his monthly remuneration, contrary to clause 3 of the contract agreement. And after repeated demands, which the defendant failed to address, the claimant instituted this action, claiming for payment of his outstanding salaries, medical and leave allowance, among others, after his contract was terminated. However, the defendants contended that the contract agreement is a simple contract and not a contract of employment, hence outside the jurisdiction of this court. In determining the nature of the contract of employment, the Supreme Court, in the case of Shena Security and Afro Park Nigeria Limited, has laid down the following factors that could guide the course in determining which kind of contract the parties entered into. And I quote, number A, if the payments are made by way of wages or salaries, this is indicative that the contract is one of service. If it is a contract for service, the independent contractor gets his payment by way of fees. In like manner, while the payment is by way of commission only or on completion of the job, that indicates that the contract is for service. Number B, while the employer supplies the tools and other capital equipment, there is a strong likelihood that the contract is that of employment or of service. But while the person engaged has to invest and provide capital for the work to progress, that indicates that it's a contract for service. Number C, in a contract of service or employment, it's inconsistent for an employer to delegate his duties thereunder. It becomes a contract for service. Number D, while the hours of work are not fixed, it's not a contract of employment / of service. See the case of Millway Southern Limited and Wilshire. It's not fatal to the existence of the contract of employment that the work is not carried out on the employee's premises. However, a contract which allows the work to be carried on outside the employer's premises is more likely to be a contract for service. Number F, where an office accommodation and a secretary are provided by the employer, it's a contract of service / employment. Unquote. Looking at the parties' contract agreement, clause 3 provides for basic salary, bonus, medical and pension allowance, and local allowance, while clause 4 has also made provision for claimants' entitlement for leave of 60 working days and 2 business class flight tickets in a year. Clauses 5 and 6 have made provision for resident permit, accommodation, and transport respectively to be provided by the employer. And clause 8 states that the defendant has the right to terminate the contract by giving 1 month notice or basic salary in lieu of notice. Going by the content of the contract agreement, it appears that the contract was meant to create an employer-employee relationship between the parties. It is thus a contract of service, not just a contract for service. I believe that if the claimant was an independent contractor, his mode of payment would not have been by way of monthly salary, but by fees or commission. I also wish to believe that the termination of contract of an independent contractor may not need to be by way of any salary in lieu of notice. I need to state that even though the contract agreement is captioned freelancer agreement, which definition was given by the defendant in the 2 dictionaries cited above, but the court will always look at the intent of the parties rather than the form of the agreement. I need to refer to section 254C1 of the 1999 Constitution, which expressly confers exclusive jurisdiction on this court to determine issues arising out of the loss. And I quote,
my wife is in the hospital, so.
You are disturbing us in Okona and Idara. I need to refer to section 254C of the 1999 Constitution, which expressly confers exclusive jurisdiction on this court to determine issues arising out of workplace or relating to employment. It states thus, and I quote, notwithstanding the provisions of sections 251, 257, and 277, and anything contained in this constitution, and in addition to such other jurisdiction as may be conferred upon it by an act of the National Assembly, the National Industrial Court shall have and exercise jurisdiction to the exclusion of any other court in civil causes and matters resulting to or connected with any labor, employment, trade unions, industrial relations, and matters arising from workplace, the conditions of service, including health, safety, welfare of labor, employee, worker, and matters incidental thereto or connected therewith, unquote. Going by the above, I have the opinion that the contract between the parties in this case is for employee/employer relationship. On the contention of whether the third defendant is a necessary party, it is important to note that for an action to be properly constituted so as to vest jurisdiction in the court to adjudicate on it, there must be a competent plaintiff and a defendant. See the case of Ataguba and Gura. It is tried that parties to an action have been classified into four, namely A, proper parties, desirable parties, necessary parties, and nominal parties. See the case of Dapier Long and Lalong. Now, a necessary party to a suit is a party who is not only interested in the subject matter of the proceedings, but also a party in whose absence the proceeding will not fairly be dealt with. Consequently, without his being a party in the suit, the court may not be able to effectually and completely adjudicate upon and settle all questions involved in the suit. See the case of Ojo and Ogbe, Mobile Oil PLC, and DENR. The whole essence of the principle of necessary party is to forestall the institution of parallel litigation by a person who ought to, but was not joined as a party in the suit. It is not squarely because he has an interest in the questions or issues involved in the case, or would prefer answers to relevant questions thereto, or whether it is necessary to hear him for that purpose. There must therefore be questions in the action which cannot effectively and completely settled unless he is a party. See the case of P North Investment Limited and Hotel Presidential Limited. It was averred by the claimant that the third defendant is one of the directors of the first defendant, and that was not traversed by the defendant. However, the fact that the third defendant is one of the directors of the first defendant does not necessarily mean that the third defendant is a necessary party. The claims and reliefs of the claimant are for, among others, his outstanding salary and allowances. And I wonder whether, in the absence of the third defendant, the proceeding in this case would not fairly be dealt with. I think, with or without the third defendant being a party in this suit, from the pleadings and documents filed, this court will be able to, without any hitches, effectually and completely adjudicate upon and settle all questions involved in this suit. In the circumstance, therefore, I have no reservation that the third defendant ought not to be joined in this suit, and I so order. Turning to the third ground of the objection, I need to refer to Order 2, Rule 1, Sub-Rule 1 of the rules of this court, which says that, and I quote, subject to provisions of this act on transfer of cases, an ordination process in respect of a matter in which the court has jurisdiction shall be filed in any register of the court nearest to where the defendant or respondent resides or has presence, or in which the defendant or respondent carries on business, unquote. From the pleadings of the claimant, it was stated at paragraph 1 of the statement of facts that the claimant was engaged by the defendant to provide professional services in Uyo, Akwa Ibom State. And the defendants admitted this much in the paragraphs 2, 10, and 12 of the joint statement of defense, and further stated that it was the Akwa Ibom State government that awarded contract to Land Sea Construction and Engineering Limited for the construction of road in Akwa Ibom State, which the first defendant was engaged as consultant to the project, who also brought in the claimant for the purpose of the project. From the above, therefore, this court has the territorial jurisdiction to determine this suit for the fact that the claimant was engaged to render his services in Uyo, which is the President Judicial Division of this court, Rivers State and Specialist Consult, Monument Bank PLC and Gaffarwan Company, AG Yobe State and Masca. In the light of all the foregoing, therefore, I find against the contention of the defendants that this court lacks the required jurisdiction to entertain this matter. I resolve the issue formulated in the preliminary objection against the defendants, but the contention that the third defendant is not a necessary party is hereby sustained. Accordingly, the notice of preliminary objection lacks merit and is hereby dismissed, but succeeds only in part. So, Mr. Tamka.
My lord.
It succeeds in part.
I see, my lord.
The third defendant is struck out.
As the court pleases.
So, Mr. Tamka.
Yes, my lord. We thank this honorable court on behalf of the claimants. Well considered judgment. We never knew that, my lord, we write so much long ruling this morning over the issue that could have been pronounced upon. We thank God for this industry employed into this ruling this morning, my lord. Thank you so much.
Thank you. So what do you do now? We adjourn for
a hearing, my lord.
Okay.
I don't know whether we can have an indication from the courts as to which date is convenient.
Okay, let's hear from Okon, the registrar.
Mrs. Okon.
Yes, ma'am.
Date.
My lord, the 4th of July.
Okay. Mr. Tamka, issues have been joined.
Yes, my lord. The 4th of July is not convenient to us, my lord, because we are at the Federal High Court on that day, my lord. But the 3rd of July is the 3rd and 2nd of July are convenient if the court is so mindful to give us any of those dates.
Okon.
My lord, the 3rd is convenient.
As a court pleases.
Mr. Tamka.
My lord.
There isn't any pending application.
No pending application whatsoever, my lord, to my knowledge.
Okay. Okay. Okon, you said in
the 3rd of July.
Okay.
So 2 days. Yeah, it's just second and third. So that's
So case is adjourned to the 3rd of July 2024 for hearing.
As a court
As a
visit.
court,
Hearing notice shall be issued and served on the defendant.
as a court visit.
as a court visit.
Yes. So, Okon, where are you? I can't see you. Okon. Okon, I can't see you.
Mrs. Okon,
Anyway, it's okay. It's okay. In the absence of any other thing, the Mr. Tamka and your
I can't see you. Show your face.
Mr. Ongiku,
Yes, my lord.
that will be all for today.
As a court visit, my lord.
As a court visit.
Yes, I wish you
We are
happy
grateful.
weekend in advance.
We can. Thank you so
In
much.
advance.
Thank you, my lord.
Thank
Okay,
you, sir.
thank you, Mr. James. So I rise for now. Thank you. Bye bye.
Thank you, my lord.
All
Bye.
right, ma'am. Thank you. Bye-bye.
Thank you.
Just stop video. Just stop video.
Anyeri. Infana.